and welcome to the Accretive Employee Benefits Compliance webinar. My name is Kevin Knopf, and I am Vice President of Communications for Keenan, an Accretive company. This month, we will be diving into alternative plan options and a legislative update. As you know, the employee benefits landscape is constantly evolving and presenting new challenges and opportunities for employers and plan sponsors. That's why we are hosting these monthly webinars to provide you with the latest updates and on a number of compliance topics that may affect your employee benefits plans. Our experts today are Amy Donovan and Lauren Fisher. Amy is the Senior Vice President and Chief Counsel of Employee Benefits Compliance at Accretive. She has more than 20 years of experience in employee benefits law and compliance, and she oversees the legal and regulatory affairs of our employee benefits division. Lauren is the General Counsel of Boone and GSA, which are Accretive companies that specialize in providing fringe benefit solutions for government contractors, and she serves as corporate counsel for Accretive. Lauren has 20 years of experience in employee benefits law and routinely advises on compliance issues, including ERISA, HIPAA, Affordable Care Act, Service Contract Act, Davis-Bacon Act, and other prevailing wage laws. Before we begin, I would like to remind you that this webinar is for informational purposes only and does not constitute legal advice. You should consult with your own legal counsel before taking any actions based on the information presented here. Also, please note that this webinar is being recorded and will be available on the Keenan and Accretive websites for future reference. If you have any questions during the webinar, please type them in the Q&A box and we will try to answer them at the end of the session. Without further ado, I would like to hand it over to Lauren. Lauren, the floor is yours.
Good morning, everyone. Thanks for joining us today. Wanted to start by just walking through the agenda. We're going to start the conversation today about the history of employer-provided healthcare and how we got to where we are today. Current employer concerns with traditional group health plans, and presenting HRAs as an alternative and the different types of HRAs to group health insurance. And then legislative update, because a lot is going on in both DC and states regarding different ways to handle employer-provided health insurance. So going back to the start of the agenda, the history of the relationship between the employer and employee benefits. And I know this is a little dry, but bear with me. So going back to the 1920s is really when employers started offering different voluntary programs for health coverage. Baylor University Hospital was one of the first, and it was offering one of the first Blue Cross plans to Dallas Public School employees down in Texas. Their choice of employee groups as a foundation of the private health insurance market that kind of started from there. After World War II, the War Labor Board imposed wage and price controls on employers, but the insurance and pension funds were not counted as employee wages. So employers started adapting and offering these things to help attain and attract working employees. In 1954, the tax code was clarified to specifically allow employer contributions for health benefit plans as a tax-deductible benefit expense, as well as excluding it from the employee's taxable income. Amy is going to talk a little bit later today about how there may be a potential shift in this area or concerns to that regard. And then in 1974, so about 20 years later, ERISA was passed, and it gave employers more flexibility by essentially creating the self-funded market so that employers could not be subject to the state Department of Insurance level. And departments of insurance of each state is primarily the responsible party for insurance offerings. So ERISA gave employers more discretion in management of employee benefits. Since then, it's expanded quite a bit. 1985, again, COBRA came about to allow employees or former employees the opportunity to continue with their health coverage even after they've separated from the employer for a certain amount of time, either 18 or 29 or 36 months, dependent upon what their qualifying event was and what state they're located in. Now, COBRA isn't tax preferred because it's 100% paid for by the employee, but it at least allows the employee to continue having that employer coverage even though they've left. In 2010, the Affordable Care Act created insurer spend obligations, eliminated out-of-pocket costs, and it further entrenched employer coverage as the primary way the working population was going to receive benefits, in that it requires employees of a certain size, anyone with more 50 employees or any entity, to offer minimum essential coverage that's affordable and provides minimum value to at least 95% of the full-time employees. And I see a misspelling there. My apologies. But even if the group falls below that 50 employee marker, a lot of employers are still offering health insurance because it's deemed to be the most valuable employee benefit offering that an employer can provide to its employees. So moving now to concerns with traditional health plans, because employers are looked at as being the primary provider to the working population of employer health insurance for employees. The next slide will kind of show a little bit of rub of what every employer is feeling, right? Costs are going up. There was a downward trend and then a little bit of a blip during COVID. But now with the costs just continue to go up. Inflation, hospitals, everything else is causing the group coverage market and individual insurance market as well to increase significantly, 8.8% for group and 7.5% for individual. And some of the main things that are focusing on, at least in this graph by the PricewaterhouseCoopers analysis, was GLP-1s. Everybody knows about that. That was not envisioned as being as popular as it has been, both on the diabetes side and as weight management. A little bit of what's still straggling on are individuals that delayed their care for the COVID outbreak. And so these things, there's an increased utilization that's trickling off a little bit, but it's still happening as far as employees not receiving care during that time, and then increasing utilization afterwards as COVID comes to not a close, but at least is now, I guess, under maintenance, similar to the flu. So traditional group health plans on the next slide, just kind of overviewing what it is. Employers offer comprehensive coverage for employees and their dependents. It's a single policy, generally sponsored by the employer. The employers, with coordination of brokers and other vendors, select the plan offerings and handle plan administration, which is generally outsourced either to the insurance carrier or to a third-party administrator if it's a self-funded plan. For insured plans, the carrier assumes the risk of those exponential costs, but the premiums are set by the carrier. So the premiums are generally higher, and the employer-sponsored healthcare coverage is expected to increase by 9% in 2025, and that isn't going to go down. So the average cost per employee per year is about $16,000. For self-funded arrangements, the employer assumes the risk, which allows the employer to at least not be helping to fund some of the other entities in the carrier's book of business. But the flip side of that is it exposes the employer to some unforeseen or unpredictable costs, like the GLP-1 drugs, gene editing therapies, which are coming out more and more every day, but they're also very, very expensive, and then the increased utilization. So those contributed to, or just examples of some of the unpredictable costs that self-funded group arrangements that employers offer can expose the employer to potentially even more than what a fully insured plan would cost. And the average employer subsidizes 81% of group health plan coverage for employees. So a lot of the brunt is being borne by the employers in this. But because the costs are going up, it's across the board. Some traditional ways to reduce the cost of traditional group health insurance. The plan design, you can move to a high deductible health plan. When those came out, the intention was employees will take more in their care when they're paying more part of it, right? So if I am responsible for the first $10,000 of my deductible, I'm going to be very cost conscious and savvy about where I'm going to go and what services I'm going to take advantage of. They, creating a health savings account allows the employee to contribute money and the employer to contribute money on those first dollar coverages before that deductible is met. An employer can consider going self-funded so they have more control over what can and can't be covered. Under the Affordable Care Act, in different states, essential health benefits, insurance carriers are required to provide numerous things, but under a self-funded arrangement, an employer does have a little bit more flexibility as to what they can exclude. And then there can be tiered co-pays or co-insurance as a way to further control the costs on the employer. The employer can implement wellness programs, incentivizing education, getting the preventive care that's covered at no cost under the Affordable Care Act to promote healthy lifestyle and choices, meaning healthier employees generally cost less and are gone less. So there's less unproductivity on the staff. Again, employee education, encouraging telehealth. That's both on the productivity side as well as the less cost intense side. And healthcare assistance programs. There are a lot of consultants and vendors out there that can help an employee navigate where to go. That again is an effort to further decrease costs. Another alternative are health reimbursement accounts. And so we are going to talk about these. These have been around for quite some time. Started in the 1960s and 1990s, employers were offering reimbursements for expenses that were not covered by their health plan. In 2002, it was solidified as being a health reimbursement account that allowed for employer-funded contributions to actually be a health benefit and allow tax-free reimbursement for certain healthcare expenses. Under HRAs, generally, it can only reimburse for qualified medical expenses that are under and outlined under Internal Revenue Code, Section 213D, that are incurred by the employees or their dependents or some former employees under certain arrangements. TPAs, third-party administrators, often substantiate the claims to make sure they qualify under 213D. They provide the participant communications, customer support, enable the use of debit cards. The key for health reimbursement accounts is it caps what the employer's exposure is, right? They're providing a dedicated amount. The HRA has to be 100% employer funded. Unspent HRA dollars can roll over from year to year. They cannot be cashed out again because that wouldn't be a 213D qualified medical expense. Under the HRAs, they are considered a self-funded plan. So they're subject to ERISA, HIPAA, COBRA, the Affordable Care Act when it came out. And the Affordable Care Act limited the flexibility of HRAs quite a bit because of the ACA standards of not being able to have a maximum amount of contributions for certain things. And HRA is that in a nutshell, right? I mean, the employer is maxing its contribution at a set amount. So under the ACA, HRAs were allowed to continue to exist, but they had to be integrated with a major medical plan in order to qualify under the ACA in order to continue to be permissible. And so that became, you had to tie it to a major medical plan. And not only does it have to be offered, the employee had to be enrolled in that major medical plan in order for it to meet the ACA standards. Then came the QSARA, Qualified Small Employer HRAs. Congress created these alternatives in 2016. It helps employees purchase individual coverage for qualified medical expenses. This is really only available to group health plans or employers with fewer than 50 employees. So again, there's not that trigger of the ACA, but it allows a standalone HRA. It's not considered a group health plan, so therefore it's exempt from numerous group health plan requirements like ERISA and COBRA. It's a defined contribution model, again, typical with a traditional HRA, right? Employers set the amount of money that they're contributing up to the annual contribution limit set by the IRS. In 2025, that's $6,350 for individuals and $12,800 for families. Limitations on the QSERA are, again, it's only available to employers with fewer than 50 full-time employees. The employer isn't able to offer any other group health plan within its controlled group. And then because it's a self-funded plan, the non-discrimination rules of Code Section 105H come into play. So QSERAs really haven't been widely adopted because of these limitations. In 2019, the DOL and the HHS created the individual coverage HRA, and this was in response to the first Trump administration's executive order. It's applicable for plan years on and after January 1, 2020. The intention is to increase utilization of HRAs under the current platform of allowing an employer to provide a set amount of dollars, tax-free allowance for an individual to go on to the exchange to purchase individual health coverage. The ICHRA can also, again, reimburse for those out-of-pocket medical expenses qualifying under 213D. The ICHRA is available to employers of any size with at least one non-owner or non-spouse employee. It's non-integrated HRA again, so it's considered to be integrated with the qualifying individual health coverage or Medicare. So that's how it's still compliant under the ACA. Employers can decide how much they want to contribute. There is no minimum or maximum, so that vastly differs from the QSERA. The employer can set a different amount for employee only and employee dependents. There are limits to that, but it allows an employee to participate. They have to be enrolled in individual non-accepted benefit coverage. So they have to have some type of major medical plan. It cannot be an indemnity benefit. It has to be major medical coverage likely to have been attained on the health exchange or through Medicare. And it reimburses employees for their qualifying medical expenses, including premiums for individual coverage. So highlighting some pros of the ICHRA. So the advantage is, again, under traditional group health plans, the employer's liability is capped. This is a self-funded plan. Employers are committing to what they can contribute. And there's no maximum or no minimum. The employer gets to decide, and the employee then uses those dollars to go and enroll in individual coverage. It limits the unpredictability of being a self-funded group health plan. It limits the employer's involvement about what they are going to offer and how they offer it. So it really takes the employers out of the market. The employee is able to enroll in the coverage that they think is best for themselves and their family. The employer can decide whether to give the full benefit as similar to an FSA, meaning if you're employed on day one, you get this entire benefit, or to have it separated out so that if someone becomes eligible mid-year, they can either get that full amount again, or they can only get a pro rata portion of it. So it gives employers a lot of flexibility. It is a self-funded plan, but the non-discrimination rules of 105H don't apply. And so the employer doesn't have the obligations to run those testing for each year, which do have an expense and concern. The non-discrimination rules under 105H are a little bit more regulatory intense than the non-discrimination rules under Section 125. Some cons of the ICHRA. So it needs to be offered on the same terms and conditions to all employees within a specific class. It doesn't go to the extent of the QSERA, meaning you can't offer any other group health plan if you offer an ICHRA, but you can only offer an ICHRA to those employees within a certain class. The amount of contribution can be distinguished based on age, up to 3x of the amount for the youngest participant and family size. So it cannot be anything other than that. It cannot vary anything other than that. The employee is required to maintain that individual non-accepted benefit coverage in order to have access to the funds and be reimbursed. So that requires substantiation, and there needs to be monthly proof that that employee is maintaining that coverage in order for those premiums to continue to be reimbursed. The ICHRA is not exempt from ERISA, COBRA, and the ACA. Like I was mentioning, it's deemed to have coordinated and merged with the individual coverage is how it's complying with the ACA stipulations. Funds cannot be used towards other group health coverage. So if you have an employee that is gaining coverage through their spouse's group health plan, the ICHRA funds can't be used to reimburse for that spousal portion of the monthly premium, and it can't be used towards TRICARE. Another con is individual coverages on the exchange are usually not as good as group health insurance. So there needs to be a lot of employee education about what that means. But, flip side, it does give the employees more control. As premium rates increase, the set amount of employer contributions, even though there's no maximum or minimum, it's going to cover less of the percentage of the payment obligation. So the employer needs to be mindful of that if they want to move forward with an ICHRA, it's setting a contribution amount that may deal and help offset even with that continued inflationary growth. If the employee is being reimbursed under the ICHRA, the employee is not eligible for that premium tax credit on the marketplace. So that is very much important to advise the employee of, so they don't claim the credit on the front end and then have to pay it on the back end on their tax return. And it may be problematic. Again, it's subject to the non-discrimination rules. So as it varies between different classes. So that's another reason why employers need to coordinate with their broker and make sure that when they set up an ICHRA, they're setting it up properly. With that, I am going to transfer it over to Amy so that she can discuss another alternative, which is the associated health plans. Thanks, Amy.
Thanks, Lauren. I learn something every time I listen to a colleague talk about benefits, so I am deeply appreciative of working with colleagues like Lauren Fisher. I am going to just fumble for a minute here because I'd like to get this slide up on my screen so that I can look at all of you. We keep getting asked about association health plans, so we wanted to spend a few minutes sharing with you what we know right now. An association health plan is a type of multiple employer welfare arrangement that has existed for decades. It's not new. There was a history of some fraud and insolvencies with some association plans that made many regulators wary of these arrangements, especially in the 80s and 90s and the early 2000s. I just have a couple of incidences here. Between 1988 and 1991, multiple employer entities left about 400,000 people with medical bills exceeding $123 million, according to a 1992 GAO report on association plans. And then again in 2000, between 2000 and 2002, 144 entities left about 200,000 policyholders with $252 million in unpaid medical bills. So there were some bad actors in this marketplace. Even as late as 2017, the New York Times reported major fraud cases coming out of some association plans in Texas, New York, New Jersey, Florida, South Carolina, and Louisiana. So when Congress was considering passing the ACA, they included some enhanced regulatory oversight of association health plans. So that association plans that enrolled individuals or small groups are subject to the ACA individual and small group market rules. That makes association plans, generally speaking, less attractive to some employers, and they're required to offer essential health benefits. There is an exception. An association plan covering small employers can be considered a single large group health plan under ERISA if it meets certain requirements. So the employers have to have been bound together by a common interest beyond health coverage and effectively operated as one employer controlling the association. The employers have to share a common trade, business, or profession, and a shared geographic location like a chamber of commerce is not enough under these rules. Furthermore, the exception does not apply to individual sole proprietors. So under these ACA rules for association plans, there can never be an association of individuals considered a single employer and can't be regulated as a large group. And that is the situation that we had for about 10 years under association plans until the first Trump administration. So in 2018, the Department of Labor greatly expanded the circumstances under which an aggregation of small groups could be considered a large group. There were criteria for this, but the criteria were much less stringent than had been in place. So an association that served at least one substantial business purpose other than providing health coverage, even though its primary purpose was offering health coverage, could be considered a large group. The member employers could be either in the same trade or business or in the same geographic area, and the geographic area could be quite large. It could span several states. Employer members would have to, in some sense, control the association plan and the health plan. Other features of association health plans under this rule, under the first Trump administration, was that the association plan could cover working owners, that is, could cover individuals, even though they had no employees other than themselves. Association plans under those rules were prohibited from discriminating against enrollees on the basis of health status, but the plans could be allowed to exclude or charge higher premiums to employers on the basis of age, gender, occupation, or other factors. There was a great deal of interest in these plans. A number of chambers of commerce rushed out to provide association plans under these rules. However, the rules were struck down pretty soon afterward in 2019 in federal court as violating ERISA. The Trump administration did appeal, but as we all know, there was a change in administration in 2020 through to moving into 2021. The Biden administration had different priorities when it came to health coverage. And did not pursue the appeal. And then in fact, in 2024, rescinded the Trump administration rule on association plans. At this point, we simply don't know whether the Trump administration will seek to revive these rules. There certainly is still a great deal of interest in this out there in the small employer community. And it's just really too early to say how the Trump administration will pursue this, whether this will be a priority under HHS and the Department of Labor this time around. Furthermore, it is a little complicated because of the way in which this rule was struck down before it was rescinded. It's not necessarily as easy as just reviving the rule. I think the Trump administration would have to deal with some of the some of the reasons why federal courts struck down the rule. So this remains to be seen, but it's an area where we're very interested in providing information to you as this may change over time. So rounding out those alternatives to traditional health plans, this is an area where we continue to look for ways for employers to innovate and save money while providing a good value to their employees. And we will continue to update you on this as things change. Now we're going to turn to a little bit of a legislative update. I'm going to be talking about both the states and the federal government. This is a little bit of a grab bag, but things are moving pretty quickly, as Lauren said before, and we want to make sure that as we talk to you every month about compliance and changes in compliance, that we're talking about these new rules, either new agency rules or new legislation that's popping up around the country. So with that, I wanted to spend a few minutes updating you on telehealth and high deductible health plans. This has been an area of real consternation for some of the employers out there. The rules under COVID of relaxing the requirements for and allowing first dollar coverage for telehealth if for folks that participate in a high deductible plan. I think that was very popular. It remains very popular, and a lot of us in the broker community and in the employer community were disappointed when those rules were not extended. So they were almost extended at the end of last year, beginning of this year. There was a bipartisan continuing resolution agreed to in January, just before the Trump administration came back into the White House. Unfortunately, for those of us who have these arrangements, incoming President Trump and Elon Musk provided feedback that resulted in that continuing resolution not moving forward. It was renegotiated. There was one signed, but it did not include the extension of the COVID era telehealth exception to the high deductible plan HRA rules. So the continuing resolution as approved in January did not include that extension. And then it really only moved the needle to mid-March, which we have just gotten through. We're hopeful again that there would be a continuing resolution that grandfathered in these health plans. And that again did not happen. So the continuing resolution that was just signed into law on March 15th did not include an extension of the ability to provide first dollar coverage of telehealth under a high deductible plan with an HRA. That continuing resolution expires September 30th, 2025. We are again hopeful that Congress will pass a full budget and not continue to pass these continuing resolutions that just basically kick the can down the road in terms of coming to a budget agreement. And we are hopeful that it will include this telehealth expansion, which many of us have found so helpful to employees. To that end, there's actually been a standalone bill introduced in Congress recently. So the Telehealth Expansion Act was reintroduced in the House and Senate on February 27th. It would provide the high deductible health plan safe harbor for an absence of deductible for telehealth. It would be effective and backdated to plan years beginning on or after December 31st, 2024. And most crucially, it would include no sunset date so that we don't have to go through this rigmarole again, and that we arrive at a set of rules that everyone understands are the rules of the road going forward without changes. It would be enormously helpful. There is a lot of support for this. There was a stakeholder letter sent to Congress recently with more than 300 signers from the insurance industry and from industries sort of all over saying that this is something that has provided value to both employers and employees, and should be extended without a sunset date. So turning from high deductible plans to another sort of hot topic for legislation, and also continuing on the theme of things that were included in that initial continuing resolution that was negotiated in December. Pharmacy benefit manager legislation does remain a bipartisan priority for Congress. It's a policy debate that doesn't really cut left to right. There are Congress members and senators that really want to make sure that the federal government is making policy with regard to how PBMs can do their business on both sides of the aisle and really across the political spectrum. So in ordinary times, this would be a little bit of a no-brainer, right? This is legislation that really ought to get across the finish line in Congress. It just really remains to be seen whether anything can get through a lot of the political logjam in Washington. So we are hopeful that future legislation could mirror an agreement that had been included in that bipartisan continuing resolution that I spoke about in the last slide that was negotiated in December of 2024, but ultimately never signed into law. Those provisions included one that said that a PBM for a large fully insured or self-insured plan would have to pass on 100% of rebates or other discounts directly to the employer plan sponsor. There were new reporting requirements, more transparency to show, where rebates are going, where other funds in all of these transactions are going from party to party. And there were additional limits in that proposed legislation imposed through the Medicare and Medicaid programs. So a ban on spread pricing, a requirement that pharmacies be paid at least NADAC plus a dispensing fee, a prohibition on tying compensation to the size of the discount negotiated. So areas where a lot of states have been legislating already. None of these are new terms to those of us who've been watching this kind of legislation for the last 5 years. But again, legislation that ultimately did not make it over the finish line. The CR, as it was enacted in January, did not include the PBM terms. There are several bills in Congress that are introducing similar kinds of limits. There is the Patients Before Monopolies Act, and that's in both houses. There's a Senate bill number and a House bill number. The Pharmacies Fight Back Act in the House, as well as the Lower Costs, More Transparency Act in the House, which we've seen in prior years as well. So there's certainly still a lot of interest in Congress in regulating PBMs and having that regulation apply across the country. Part of what has been so frustrating about PBM regulation for those of us who are watching this happen in state houses across the country is that states are still very much testing the fences. In the absence of federal rules of the road, states are all being those incubators of democracy. They're all trying to come up with their own rules. NAIC, that's the National Association of Insurance Commissioners, is looking at new recommendations for each state to at least require PBMs to obtain a license, which is true in most states at this point, and is also considering the creation of market conduct exams for PBMs. That leads me very nicely into my next slide, because we are now seeing some market conduct exams for PBMs in a couple of states. Unfortunately, they are really providing some confusion for employers in terms of what needs to be done to comply with these market conduct exams and what employers may be risking in compliance. So I want to talk for a couple of minutes about Arkansas Rule 128. This is a rule that was enacted to make sure that reimbursement rates paid by PBMs to pharmacies in Arkansas were fair and reasonable. And again, it is the same kind of rule that we're seeing in being considered in federal legislation. So requiring PBMs to pay pharmacies at least the national drug acquisition cost plus a dispensing fee. And that rule, in that rule, enforcement authority for the rule was given to the Arkansas Insurance Department. The Insurance Department issued Bulletin 18-2024, and that bulletin requires that data be provided in this market conduct exam by fully insured group health plans issued in Arkansas, by fully insured group health plans issued outside of Arkansas that cover Arkansas residents, and by self-funded group health plans, including government plans that provide benefits to Arkansas residents. It's the extraterritorial impact and the impact on self-funded group health plans, which are covered by ERISA and usually exempt from state regulation, that has caused a lot of confusion among employers. Compounding the confusion has been some language that in the bulletin that seems to conflict with Rule 128 itself and is creating an ERISA issue for employers. Rule 128, the rule itself, carves out federally regulated health benefit plans restricted from state regulation under federal law, or those health benefit plans which are exempted from state regulation under state law. And so that seems to exclude self-funded health plans that are regulated by ERISA. The bulletin, however, expressly states that the rule applies to self-funded employer health plans and self-funded government health plans. And this is potentially in conflict with ERISA. I know that there are many employers listening in today that have sought some clarity on this, wondering whether they should comply, have been contacted by their PBMs and asked whether the PBM should submit data on their behalf, or are wondering whether they should be submitting data on their own. The initial date for compliance with this was in the beginning of the month. So I think most of you who were dealing with that have come to some understanding of how you will proceed. But what we have been advising employers is that in this case where the law is really unsettled and unclear, that's a point where it's important for you as an employer to consult your own legal counsel regarding all of the implications of compliance. And we still encourage those of you who are dealing with these kinds of questions to seek your own legal advice on this matter. It is really an area where the law is not settled. We're seeing a similar issue now in Florida. There's a Florida data call for data that is related to Florida SB 1550, which was passed in 2023. That is a law that regulates PBMs. In January in 2025, the Florida Agency for Healthcare Administration requested that PBMs turn over detailed prescription data, including patient names, birth dates, medications, prescribing providers, and dispensing pharmacies. This is a level of detail that we have not seen state insurance departments require. And they sought this data from self-funded ERISA plans. This is certainly HIPAA-protected data. And again, this is an area where employers have really been concerned about compliance, especially because this is HIPAA-protected data. The American Benefits Council has asked Florida to withdraw that request that violates the health, privacy, and security of millions of Floridians, according to ABC. And again, unfortunately, this is an area where, because the law is unsettled, because employers are caught in some ways between federal regulations on the one hand and state regulators on the other. We urge you, if you're stuck on compliance with these kinds of data calls, that you consult your own counsel regarding the impact of compliance and make sure that you as an employer are protected. Turning from those PBM issues in the states, I did also want to spend a few minutes talking to you today about what's happening in California. I know that not all of you are located in California, but many employers have California locations, even if that's not where you are based. And California has made an enormous change to what's covered under fully insured health plans. So effective for plan years beginning on or after July 1st, 2025, California will mandate that fully insured health plans cover infertility diagnosis and treatment. We've gotten some questions on this because in his signing message, when Governor Newsom signed this legislation into law last year, he urged the California legislature to put off enacting the legislation. He signed it into law, said, yes, I think this should happen. I think that this mandate should go forward, but I think that this is not enough time. However, that recommendation has not been taken up so far by the California legislature, and the California legislature has passed its February deadline to introduce new legislation for 2025. It was not included in any of those bills. I'm not saying it couldn't happen. It certainly could be. A delay could be amended into budget legislation or other must-pass legislation before July 1st, but we're really running out of time. And there doesn't appear to be a groundswell of pressure to put this off for a year. The rule itself, the law requires fully insured large group health plans in California to cover infertility, diagnosis, and treatment for up to 3 in vitro fertilization cycles. It requires carriers for small group plans to offer the option to the employer of covering infertility diagnosis and treatment. The way this is written in the statute is a little confusing to folks who are not used to reading California statutes, but it is clear from the way this is written that small group plans do not have to cover infertility diagnosis or treatment, but that carriers have to offer small group plans the option of offering that coverage to employees. That's one of the questions we've gotten over and over again on this law as we've been talking to clients about it. The law is quite broad in who it covers. It covers unmarried partners, same-sex partners, and individuals. Basically, anyone who is unable to reproduce either by themselves or with their partner without medical intervention can get coverage for infertility diagnosis and treatment. The law states that it is required, insurance companies are required to give this coverage without discrimination on the basis of age, ancestry, color, disability, domestic partner status, gender expression, gender identity, genetic information, marital status, national origin, race, religion, sex, or sexual orientation. So it applies to almost everyone. Did I? Okay, so sorry about that. So basically, where we are with this law at this point is that it is going to into effect on July 1st. What remains to be seen with this law is how much of infertility treatment needs to be covered under the plan. There is language that requires the coverage to be given without regard to having a third party assist with with egg donation or with surrogacy. And there are questions in the insurer community about how much of a mandate that is for coverage under the plans. Carriers that we've spoken to have already looked at this. They're ready to implement this summer. They anticipate that this may raise rates for 2026. We also understand that for those of you who offer Self-insured plans alongside a fully insured plan in California may seek to mirror the California mandate in your self-funded plan, even though you are not required to. I urge you to speak to the underwriters for your self-insured plans. I know that at Keenan, one of the accretive companies, the underwriters have been very busy modeling this and figuring it out for their self-funded clients that are seeking to mirror this coverage. So with all of that said, and what's happening in the states, turning back to the federal government, how may this change in the future? We're looking at maybe a smaller Department of Labor under the second Trump administration. The Trump administration's focus to eliminate unnecessary administrative expenses and reduce the size of the federal workforce is quite an endeavor. And so we are looking at smaller federal agencies, really, I think, across the board, HHS, as well as the Department of Labor. Certainly fewer resources for employer plan audits. So we're not quite sure how robust auditing and enforcement of compliance is going to be in the coming years. The administration also imposed a regulatory freeze that prevents all new federal rules from going into effect until the current administration can review it. So certainly that implicates the HIPAA security rule to strengthen cybersecurity for EPHI, as well as the Mental Health Parity and Addiction Equity Act non-quantitative treatment limitation rule updates that were scheduled to go into effect at the end of this year. They are currently paused. I know that has been an area, especially for our some of our self-funded plan clients, that has been the subject of some consternation. There is still, under current law, a requirement that your plan have a comparative analysis of your non-quantitative treatment limitations, but the piece of that was scheduled to go into effect at the end of this year has been paused. We also are looking at potentially, as Congress is looking at extension of the Tax Cuts and Jobs Act at the end of this year and trying to put into place a comprehensive budget package by September 30th of this year. People are looking at the longstanding preferential tax treatment of employer-provided insurance, which has gone back to 1954. And there is some risk that it could be used to offset the congressional intent to make these cuts permanent. Making those cuts permanent has a $5 trillion price tag. It's quite a lot of money. And so Congress has been and will be looking for so-called pay-fors, things that they can cut from the federal government, other ways of bringing in revenue. So that takes me to my final slide. Those of us who have been in employee benefits law and compliance over the last 20 years certainly remember the Cadillac tax. And the Cadillac tax was a tax that was included in the Affordable Care Act originally, that would tax employers for the value of employee health benefits that were above certain thresholds. It was intended to sort of put a lid on prices and on the generosity of those benefits and drive down health inflation in that way. It was supremely unpopular. It was supposed to go into effect and was delayed several times by Congress. And then finally, Congress repealed that part of the Affordable Care Act. So the Cadillac tax never went into effect. However, in March of 2024, the Republican Study Committee's Budget and Spending Task Force released its budget proposal, which included something that feels a lot like the Cadillac tax, a limit on the tax treatment for healthcare expenditures, including amounts paid by both the employer and the employee. Now, that has not come up so far as far as we know in budget committee hearings this year, but last year it was certainly looked at. So the question is, what would happen if the tax exclusion for employer-sponsored insurance was capped at, say, 75% of the average in 2026? And then indexed for inflation using changed CPIU. So that would mean that it would be capped at $11,200 individually, $27,600 for a family. Because it would be indexed using chained CPIU, and because chained CPI rises much more slowly than just regular inflation, and certainly much more slowly than medical inflation and health insurance inflation. By 2020 through 2032, it has been analyzed that this policy would limit the tax exclusion to, in fact, the 50th percentile of premiums. So $8,900 per individual and $21,600 per family in 2026 dollars. Some of the impacts of this could be that about 2.8 million fewer people would have coverage through employment by 2035. And certainly we know that most employers would look to move toward perhaps less robust coverage and other ways to stay under the cap so that they were taking full advantage of the tax treatment of employee benefits, and employees would not be penalized for more expensive coverage with a tax on that more expensive coverage. Other long-run impacts have been modeled, including $40 billion perhaps less in GDP in the long run, 240,000 fewer jobs annually, and $280 billion less in after-tax employee compensation. So this would be a tremendous change if it came to pass. I tend to think that nobody in Congress has quite the appetite for this kind of change in employee benefits. I think most of us see the value in currently being able to pay for our benefits pre-tax. And this would be an enormous disruption in the employer community as well. So we are hopeful this does not come to pass. We are certainly watching what happens in Congress very closely. And we'll continue to keep you updated, but I think it's important that those of us who deal with benefits every day understand that their lawmakers may look at all of this with different eyes, and certainly everything that we have relied on as set in stone could change. And we will continue to give you all of the information you need to make decisions for your plans as we roll forward. So with that, I'm going to ask Kevin Knopf to talk to you for a few minutes about who we are and what we do. Thank you.
Thanks, Amy, and thank you, Lauren. And I'll be very quick here because I know we're short on time and we want to get to some questions. But before we get to some audience questions, a reminder that this presentation and the recording will be available on the Accretive and Keenan websites. As I mentioned before, this webinar series is brought to you by Accretive. For those of you not familiar with Accretive, we are a leading provider of specialized property and casualty insurance and employee benefit solutions. And our capabilities extend beyond traditional insurance offerings. Accretive specializes in cost controlling solutions that encompass comprehensive enrollment services, medical stop loss programs, pharmacy benefits management. These services are designed to manage risks effectively while optimizing costs, ensuring that both the employers and employees receive the maximum value from their benefit plans. Additionally, we offer innovative solutions in healthcare, retirement planning, and voluntary benefits, all aimed at providing a holistic approach to employee well-being and financial security. In addition to working directly with employers, we collaborate with brokers to enhance their service offerings and address the evolving needs of their clients, providing further value and support in the competitive insurance landscape. You see on the next slide here, we have more than 40 specialty companies with offices in the US, UK, and Ireland. Amy, I'm gonna take the next slide is the disclaimer, and I'm gonna go ahead and read that so we can get into the questions. But Accretive companies are insurance brokerage and consulting firms. They are not a law firm or an accounting firm. We do not give legal advice or tax advice, and neither this presentation, the answers provided during the questions and answer period, nor the documents accompanying this presentation constitutes or should be construed as legal or tax advice. You are advised to follow up with your own legal counsel and or tax advisor to discuss how this information affects you. Amy, Lauren, before I hand off and get out of the way, Amy, I heard that the Keenan TPA is able to administer ICRAs. Is that true?
That's true. That's a capability that we just took on fairly recently. So if you are looking at offering an ICRA and are wondering how you're going to get that administered, Keenan TPA does have the capability to administer ICRA plans now. And those of you who are interested in that should talk to Michael Coates at the Keenan TPA.
Thanks, Amy.
We had gotten one question, and I know that we're really at time at this point, but we did get some questions about the California infertility mandate. The answer to that question, up to 3 IVF cycles, is it each year or lifetime? That is lifetime, but unlimited number of embryo transfers from those 3 IVF cycles. We have more details on that in a briefing that we've done. We've done a couple, actually. We've got a Q&A briefing out on that law in particular. We've also gotten some other questions about other state legislation. I'm going to defer those to next time, being cognizant of everybody's time. But I want to thank you all again for being with us today. And please tune in. We are doing these compliance webinars monthly, and we would love to have you participate with us.